Okay, next talk of the morning is Maria and Tina are going to be tag teaming this talk on GDPR.
Hello everyone, good morning from our team. Tina and I will present our project on the GDPR and especially Article 32, which is the security of processing requirement under the GDPR. Our project was supported by the Network Institute at Vrije Universiteit Amsterdam and was inspired by our professors Diana and Magdalena, who at the time were teaching in the departments of computer science and law, respectively. The General Data Protection Regulation was enacted in May 2016 and entered into force 2 years later in May 2018, where it was directly applicable in all EU member states without the need for further transposition by national parliaments. The overarching aim of the GDPR is basically to safeguard the personal data of natural persons against any types of data breaches. So, the material scope of the GDPR is horizontal, which means that it applies horizontally to all public or private organizations in the EU that in one way or another process personal data, whether these are in any industry, whether these are health institutions, a hospital, pharmaceutical companies, financial institutions, educational institutions. Every single organization that processes personal data falls under the scope of the GDPR. Our project has as a topic specifically Article 32 of the GDPR, which sets forth the requirements both from legal, organizational, and technical perspective for the security of processing. This is the provision, the main text of the provision of Article 32. As you can see, it's quite lengthy, it's very descriptive, but it can also be very vague at times. Because, for example, as you can see, it says that all these organizations, which we call data controllers, need to take into account the state of the art, the cost of implementation, the purposes of processing of personal data, as well as the likelihood and severity of data breach to the natural persons. However, each organization, so each data controller needs to devise and put in place security measures from organizational and technical perspective, but these need to be appropriate to the risk. But the regulation, so the provision does not say anything else more practical, so the data controllers are able to actually deploy the right measures. So our main question in this project was how to comply with GDPR, and especially how to comply with the security of processing requirement under the GDPR. When we started our project, the existing literature from a legal perspective only interpreted the law or analyzed the case law or both. And from a technical perspective, the literature at the time presented the industry standards, for example, ISO, some other practices like privacy by design or other specific technologies like blockchain that were used in terms of GDPR. And our goal was then to bridge the gap between technical and legal in the security of processing requirements, to understand how data protection authorities in all EU member states assess their cases of and complaints regarding Article 32, and how do they impose fines for the breach of the security of processing requirement, and to extract problematic patterns as well as highlight some good practices. We believe that our contribution with this project is threefold. First, we did not start by interpreting the law or by just presenting the industry standards or other practices that were used from a technical perspective to safeguard the security of processing, but we started from the fines imposed by the data protection authorities for infringement of Article 32. Then we individually annotated all the cases that we selected from legal and technical perspective to extract some specific characteristics that we thought would be valuable for our future analysis, and then we cross-analyzed them to find patterns. Some of the practical challenges that we faced was first that at the time there was no official database or repository with the complete set of all cases and fines imposed not only for Article 32 of GDPR, but all GDPR articles. So we had to rely on websites handled by law firms or other NGOs to extract our data. Then, since we wanted to include in our database cases from different European member states, of course, we don't speak all EU languages, so we had to either select cases that we could speak the language ourselves or translate the cases that we wanted to select using machine learning again ourselves. Connected to this language barrier problem was the fact that not all data protection authorities approached their decisions in the same way. So, for example, there were cases that were 2, 3 to 5 pages long, but then there were also decisions that were 50, 60, or 70 pages long. So the amount of information and the methodology that was used by the data protection authorities was quite diverse. So again, this was a challenge because we had to level the playing field there and extract only the information that would be valuable for our analysis. And finally, another challenge that we faced, but also I think it was actually a pleasure and enjoyment to work on, was the interdisciplinary nature of our project, because in the beginning we did start by analyzing some legal and technical perspectives individually, but then we had to cross-analyze and continue with the analysis of our results together. So we had to collaborate a lot. In the beginning it was challenging, but then it was actually the most enjoyable part. Delving deeper into the data that we used for our research, we focused, of course, only on Article 32. We selected 50 cases at the time, and 2 years ago, and those 50 cases by then represented only 25% of all cases on security of processing. By June 2023, the cases for infringement of Article 32 were more than 400. We analyzed cases from 19 EU countries and the UK, and the fines in our cases ranged from 0, when there was no actual infringement and the controller was compliant with the GDPR, to 28 million. And these are some of the values and characteristics that we extracted to do our automated research in the future. And my colleague Tina will continue.
I hope the mic transferred. Yes, I think it did. All right, so now that we're on the same page, let's discuss the results. So first I want to walk you through some general observations. Some of these things may be quite obvious, some of them were quite surprising to me. So for example, in terms of the medium, we find that the majority of cases relate to digital data, which of course is kind of to be expected these days. But surprisingly, there were also some physical copies involved. Mostly those were printed documents or USB drives that were handled improperly. Then in terms of the format, we find that the majority of cases involved text data, which again was quite surprising for me, because you would expect some more audiovisual data, photographs, recordings, and so on, but those didn't really appear often. Then we also find in terms of stages of processing that most incidents happen during handling of data. Then they are followed by improper disposal, and very rarely cases involve improper collection of data. Now, the next 2 points may seem a bit like a contradiction. So in terms of origin of the threat, we find that external threats are more often than internal ones. But then we also find that the majority of data incidents were actually accidents. So they were not actually malicious hackers trying to gain access into some databases. They were rather just accidents by people. Then we also find that private data controllers are more often fined than the public ones, but when they on average pay smaller fines. And finally, we find that large portion of the cases involve non-sensitive data and non-vulnerable data subjects. And of course, in terms of the fines, we find that the organizational mistakes seem to be the most costly, then technical, and finally human mistakes lead to the smallest fines. Okay, so we have some time to discuss the juicy results. So we fed all of our classification, all of our coding into a K-modes model, and that model identified 4 clusters of cases with characteristics similar to each other. Well, technically there was an extra set of cases where no breach of GDPR was identified, but we're going to leave this out in interest of time. So the first group of cases is where a breach of GDPR does happen, but there was no incident. So this may seem a bit funny and contradictory. So let me give you a more concrete example. So in this group, we would find cases where, for example, a hospital had too broad authorization, and doctors or nurses could access data of patients they were not supposed to access. So there was no explicit incident. Data didn't really get lost, but they could have, they could have accessed the data that they weren't supposed to. So here, the main issue was of organizational nature. Then we have another set of cases. So those would be the cases that actually make the news, where a malicious hacker or some malicious party gained access into the data set that they were not supposed to. So this mostly happened to private data controllers. Then we found another group of cases where non-technical mistakes happened. So those were usually small human mistakes, for example, wrong email attachments, or a mass email would get sent to people without BCC, simple mistakes like this, and they are quite common. And the final group of cases that was identified was the general breach that doesn't really belong to any other groups. So those would be sort of mid-scale data controllers where various database leaks happens and so on, this type of mistakes. Yes, so we want to stress that our work was a proof of concept, and we looked at things from a very high level, and yet we managed to identify some groups and some interesting patterns. So if this work was extended by us or any other interested researchers, we would propose a larger set of cases, of course. So we only had 50 cases, which at the time was 25%. But at this point, 50 cases is a very small set of cases. Then ideally, we would also annotate the cases automatically. So we had to do everything by hand, which was quite tedious. And this was also what limited us to only 50 cases. And lastly, of course, we would like to also do some interviews with researchers, DPAs, and really extract from them how they see the GDPR. So that's it. Thank you. And any questions are welcome, of course.
Okay, thank you. We have a bunch of questions in the chat. So the first is a question about whether the Teletrust ANISA guide on the state of the art in IT security had been out at the time that you started this. It looks like, just based on the URL, that was September 2021.
And also, we started this project in early 2020, I believe. Yeah, so things have changed since then. Yes. But yeah, at the time there was very little information, so it all seemed very confusing.
Second question, I'm skipping around because this one is the most upvoted. Did you see an asymmetry between fines and noncompliance for global tech companies versus organizations that were based solely within the EU?
I don't think so. So we looked at things from a very high level. So I cannot really comment on the differences. We had maybe a couple of companies from each of those, so I couldn't really talk about any specific patterns.
I don't think we saw any asymmetry. Also, because even if there are global companies that operate in the EU and that are not based in the EU, they have departments, and since 2018, specific data protection teams that solely handle these type of issues. So. But we didn't notice any type of asymmetry in this regard.
Okay. I'll just do two more quickly since you folks were good and we're under the time. Did you calculate an approximate measure of remedies divided by the number of victims? For instance, in Spain 2021, did individuals receive redress and to what amount? Okay, last question. Does your analysis look at how many of these were standalone Article 32 cases versus just part of a broader investigation?
Yeah, I don't think we can comment on this right now because we don't have the data, but we, in the published paper, I think we discussed this briefly, yeah.
Okay, let's thank the speakers again.